Before I remark on the secret situation, which I appreciate your allowing me to do, Mr. Chairman, I want to remark on Mr. Grath's comments. If there's no application, then it seems to me that the decision of the ZBA should be vacated, because what did you decide on if there was no application?
We decided on the denial letter that was forwarded to us by the Planning Department requesting an opinion over whether or not the covenants that had to do with the restaurant could be removed and whether or not the business depth extension for any purpose would be either affirmed or could be decided that it ran with the land. And that's the only thing that was in front of us, and we offered a decision on those two issues only.
But it was because of an application for proposed mixed-use building on that property.
I have described it as a pre-application, which is the procedure that is my understanding that the planning board has and the planning staff and department has adopted. Okay.
Well, again, let me thank you for letting me make the comments on secret, because it relates exactly to that position of what was before the CBA at the time. So the Zoning Board of Appeals failed to comply with secret when hearing and making its determination on the application. There was an application, I was at that hearing, on RT 441 owner LLC before at its August 3rd, 2023 meeting. The project subject of the application was a proposal to demolish an existing building and erect a mixed-use building. That's on the record. The applicant was before the ZBA pursuant to a letter of denial issued by the Planning Board. The letter of denial stated the relief required was a special use permit expanding the parking area for the proposed building and relief from covenants and restrictions previously imposed on the subject property. The ZBA granted the relief, authorizing the business depth extension to continue based upon acknowledging the proposed mixed-use development project, and rescinded the covenants and restrictions from the earlier grant, again acknowledging the proposed mixed-use development project. In granting the relief, the ZBA made two discretionary decisions, actions subject to SECRA. Contrary to the requirements of SECRA, the ZBA determined their grant was a Type 2 action under SECRA regulations, determining the grant to be an interpretation of an existing code, rule, or regulation. It was not. In addition, the Planning Board letter of denial indicated the ZBA would be, in quotes, lead agency under SECRA. This would have required the ZBA to undertake a coordinated review under SECRA, as the proposed project is subject to decisions to be made by other involved agencies, such as the Planning Board, the New York State Department of Transportation, the New York State Department of Environmental Conservation, the Suffolk County Department of Health Services, the Centerport Sewer District, the Suffolk County Water Authority.
Mr. White, I don't like to interrupt people's applications, but you do know that part of our decision-making process and on the record indicates that the Planning Board and staff would have to address SECRA. You do know that that was part of our decision.
That's correct, but that's in fact the additional violation of the SECRA process. You segmented the application.
Well,
you took
that's an argument.
That is an argument, but that's on the record.
I don't agree with that particular position, but that's an argument. You can make that argument if you choose. I'm trying to find out one of the things that you represented, but you may continue.
But while the ZBA did not do that, language in the grant from the ZBA would make it seem that it did. In other words, as if you did carry a coordinated review and provide the hard look that's required in the SECRA. Specifically on page 3 of the grant, it states, in quotes, the proposed construction would not have an adverse effect or impact on the physical or environmental condition in the neighborhood. But by its own record, the ZBA undertook no analysis of potential adverse impacts or effects by determining the application before it was only a Type 2 action. It not only did not take the required hard look at potential environmental impacts. It took no look at all, but still made the finding, as quoted herein above, that there was no impacts. Indeed, the language quoted from the ZBA grant would make it look like the project was an unlisted action, and then improperly giving it a negative declaration without any environmental quality review. The additional failure of the ZBA to comply with SECRA is that by confining their review to matters they determined to be a Type 2 action, the ZBA has violated the SECRA rule against segmentation. Segmentation is prohibited as by segmenting a project and only looking at a small or partial elements of the project at a time, the analysis is more likely than not to come out very different than looking at the project as a whole. Moreover, the complete SECRA review process is required to be undertaken at the earliest possible time in the decision-making process. Again, the ZBA made discretionary decisions, but failed to timely perform the required SECRA environmental quality review. Indeed, it performed no analysis at all. Simply stated, the prohibition against segmentation is to prevent exactly what the ZBA did: segment the review of the project, restricting its review to look at a single aspect or phase of the project, rather than as the law and regulations require, which is to consider the entire project at the earliest possible time in any decision-making process. In the instant case, at a minimum, the environmental quality review of the mixed-use development project proposed would include, but not be limited to, the stormwater runoff from the property flowing into the mill pond, as stated in the Planning Board's letter of denial, the change in traffic patterns and impacts of additional traffic on an already unsafe roadway, the impact to historic structures such as the Dove Tor Cottage in proximity to the proposed project, the capacity of the Centerport Sewer District, Northport Wastewater Treatment Facility, and impact of the water quality conditions of Northport Harbor that might come about from this development, impact to wetlands with the installation of new bulkheading, and, as pointed out by Mr. Berger in his letters, consistency with the New York State Coastal Zone Management criteria. I thank you for your time, Mr. Chairman, and the board.
Mr. White, I just want to make sure. Just want to make sure the record is clear. When the memorandum was presented from the Planning Department to the Zoning Board, the specific language is, the Planning Board has no objection to the Zoning Board taking lead agency status if the Zoning Board decides to proceed with the hearing. It is specific in our decision that the Planning Board has to take secret into consideration. And while I understand, you know, lawyers make arguments. You made your arguments about segmentation. I don't believe that to be the case. We actually placed on the record that the Planning Board has to take lead agency status, not us. Just making sure the record is clear.
And again, Mr. Chairman, if you look at that line that I quoted from your decision, you made a statement with respect to the environmental impacts of this project. Thereby, you seem to have assumed lead agency status, but you didn't do what the regulations and the law required.
Well, that's and I'm reasonably certain that's before the Supreme Court in Riverhead. And if what you say turns out to be true, then it will be remanded back to us.
I feel the same way, Your Honor.
And if that happens, we will. If that takes place, we will address it. But it's pending at the moment.
I just wanted to make one final comment with respect to that. Having been involved in litigation as yourself for decades, isn't it better to try to resolve this issue here rather than 3 years in the Supreme Court?
Well, it's too late to do that now.
Article 78 could be withdrawn if this board acts appropriately the way it should be acting and assigning the assignment to the Planning Board has been requested.
Well, that's the first time I ever heard that argument ever made.
Stop litigation.
So,
Less litigation is better. Thank you, Mr. Chairman.
Mr. White. Mr. McCarthy?
Mr. Chairman, members of the board, Michael McCarthy. I'm an attorney representing the property owner, RT 441 owner LLC. Clearly, we object to this appeal on a myriad of grounds, most of which are procedural, and this should not be an evidentiary hearing. This board heard every argument that was raised by Mr. Berger and the community on August 3rd, 2023. This board then rendered a decision which was recorded in the office of the town clerk on October 3rd. Every argument being raised herein is the subject of a CPLR Article 78 proceeding, and as Mr. Chairman points out, this is an attempt, thinly veiled, to re-argue what was attempted to be argued back on August 3rd. But I want to go back to the beginning and just talk about procedure. A lot of talk about standing, but what we haven't spoken about is ripeness. These arguments that are being raised by Mr. Berger and Mr. White, they're not yet ripe for review. And it's Law School 101 that if a case is not ripe for review, it's dismissed. And I'm asking this board to dismiss this appeal. And I'll tell you why it's not ripe for review, Mr. Chairman and members of the board, is because the owner of the property, who, by the way, is not named in the appeal, so that's my second reason that you should dismiss this proceeding, is because RT 441 owner, limited liability company, is a necessary party. And Mr. Berger knows me. He's known me for 35 years. He never picked up the telephone. He never gave me the courtesy of reply to the papers. But he'll stand here before the board and he'll try to besmirch my reputation or the statements that I'm making to this board advocating on behalf of a client. And I resent it, Mr. Chairman, that he would do this in a public forum. But he didn't name my client. They don't have standing. And it's not ripe for review because RT4 owner 441 hasn't filed a site plan application. The application that came before this board was for the very limited and specific relief to vacate and remove restrictive covenants that applied to the Jellyfish Restaurant property. There was an additional prayer for relief that the board not grant a business depth extension, but continue a business depth extension. And the board heard the evidence, all points that the board needs to make a determination for a special use permit, that the continuation of the depth extension, de minimis I might add, for the continuation of the parking lot would not have an impact, and that's the nature of the relief. So these arguments are circular. Now, there will be an occasion when a site plan application will be filed. The application will be made to the Planning Board for site plan review, and the reason why it's going to the Planning Board for site plan review is because, Mr. Chairman, newsflash, Hoffman Grayson Architects, with the collaboration of R&M Engineering, has designed a building that will fully and completely conform with all of the laws, rules, and regulations of the Town of Huntington without the need of relief from this board. The building was not designed that it needs relief, and that's why we're not before the board, Mr. Chairman. Now, by the way, if when the site plan application is filed in the future, and it hasn't happened yet, and Mr. White and Mr. Berger and the Centerport Harbor Civic Association don't believe in the integrity of Hoffman and Grayson, and they don't believe in the integrity of the planning department of the Town of Huntington to be able to analyze a plan as to conformance with its code, at that time they can make those arguments to the planning board of the Town of Huntington. And if the planning board of the Town of Huntington grants the relief to issue site plan approval, and they're not satisfied with the relief that's granted, they could take an Article 78 proceeding. Mr. Chairman, there's no precedent whatsoever to file an appeal from an advisory opinion of a senior planner to this board on behalf of the planning board. There's not. And now Mr. Berger is talking about 267 of the town law. Mr. Chairman, please go back and read it. He's referring to New York State Town Law, Section 267 hyphen lowercase a, paragraph 4. And that section of the law states in material part that an appeal can be taken to this board from a determination of an officer, board, or bureau of the town that makes a conclusive determination. Mr. Weider did not do that. Mr. Weeder is not an individual that's charged with the enforcement of the zoning ordinance of the town of Huntington. Mr. Weeder is a planner. He's a very good planner. The plan comes in, they analyze it. A public hearing is scheduled, and they provide an advisory opinion. So for those reasons, now, by the way, I can talk about the merits, and I gave you a letter dated January 8, 2024, and with the help of Hoffman and Grayson and Mr. Robinson, I went through each and every detail as to why it is it's false, all of these allegations. Mr. White, very well respected, professor of environmental law at Stonybrook University, and he's going to come up to the board, he's going to talk about segmentation when the board is making a very, very nominal interpretive decision as to whether or not restrictive covenants should be lifted, and he wants to argue segmentation. I defy Mr. White to provide case law to this board on the issue of segmentation and segmentation alone that doesn't state that you only have segmentation when significant and material aspects of a project are being uncoupled. It was a simple request to lift the restrictive covenants. All of these arguments that are being raised by Mr. Berger are in his Article 78 proceeding, and I suspect strongly, Mr. Chairman, that there's going to be a decision from the Supreme Court that said, Mr. Berger, very eloquently written, but untimely because you didn't raise it too late, you raised it too soon. So I would invite Mr. Berger and Mr. White and the whole Centerport Harbor Civic Association to involve themselves in the site plan application when it gets filed, and when it comes in, and when the planning board starts reviewing it, they can weigh in on it, and they can weigh in on the efficacy of the plan, the interpretation of the law, whether or not Mike and Katie are full of beans as to how it is they designed a building. But these arguments shouldn't be taking place now. And I think what's really also, and I'm on a roll here because I'm very annoyed at Mr. Berger and what he had to say at the podium. But so let me say something now. I think it's grotesquely irresponsible for Mr. Berger to create a false sense of expectation to all these people here that this board has something that they can give them tonight, because there's not. This board doesn't have any jurisdiction. There's nothing to appeal. There's nothing happening. And all of these people come out on a cold winter's night, and we got to sit here and spend all of this money and time on an application that hasn't been filed yet. It's irresponsible, Mr. Chairman. And that's all I have to say about it. And I ask that you please deny this. This is nonsense.
Okay, thank you, Mr. McCarthy. All right, Mr. Berger, I'm going to give you an opportunity to make one more argument, and then I'm going to close the hearing.
Okay, according to Mr. McCarthy, it's sort of like we're a man without a country. He'd prefer us to be citizens without a remedy. First of all, referring this to site plan review, there is no provision for public participation in site plan review. All right? Now, your decision...
I'm glad you brought that up, and so I'm sincere about that. The planning board and the planning staff has their own sets of rules and regulations, and you pointed out that they may be able to do this without public input. That is going to be up to them, but my perception is that they are more than likely to accept public input.
But that's
more than
no
likely.
That's no guarantee.
If you request it, my perception is that they will definitely take it under advisement and make a decision that they think is appropriate under the circumstances.
And I'd just like to point out, you asked, are we making a request for re-argument? I just want to point out, it's probably a little-known provision. I think it's in 267, subdivision 7 of the town law. There is a provision where the zoning board can make a motion amongst itself for reconsideration. And this may be a prime example and a unique instance where maybe there should be a reconsideration simply on the basis of the steep slope. I think, we've pretty much satisfied everybody that, first of all, it's beyond the parameters of a steep slope, beyond 10%. That's been an admission by the applicant himself in his letter subsequent to the August 3rd hearing, where he said he admitted that the slope was greater than 10%, plus we have Mr. Carpen's affidavit.
Well,
So
that's
as a baseline, we do have an admission that the slope is greater than 10%. And then we also have the specific code sections that say that hillside area is natural or man-made. Steep slope applies to all zoning districts. Steep slope pertains to new development and development where you're eliminating an existing building and putting up a new building. So all the parameters for steep slope are there. And maybe there's variances needed, maybe there aren't. But as a minimum, I think steep slope has to be the starting point before this plan can come to fruition.
And I've pointed out on several occasions that these are decisions that will be made by the planning staff board and planning board when the department, when and if and when a application is actually presented to them.
And Mr. Chairman, I appreciate your opinion, but again, I respectfully disagree. And again, I would point to
Well, then I'm going to ask you one more time. What's your prayer for relief tonight?
Well, just let me point out the code section, why I respectfully disagree with that last point you made. Again, it's 19865.1 G2. A special use permit for a business depth extension shall not be granted until steep slope has been done. And you granted a depth extension without the steep slope analysis. So,
Okay.
but again, I'll ask
What's
for...
done is done, Mr. Berger, and then it's pending before the court. What's done is done. So I'm just asking you what you want, what your prayer for relief is tonight.
My prayer for relief is, okay, number one, I would, again, I'd ask that you direct the planning department to reissue a proper letter of denial encompassing the necessity for steep slope analysis. And again, maybe I'd ask for a reconsideration under 267.7 of the town law.
Well, now I understand what you're asking for. You're asking us to ask the planning staff to issue another letter of denial so that the applicant can come before us another time.
To do steep slope, yes.
Well, that's what you're asking for. Okay, now I understand it.
And let me just point specifically, I'm going to try to put this in plain English, why this is a segmentation. So
I've heard enough about that. You had an expert talking about it. I've read that thing 100 times too, so I don't want to hear any more arguments about that.
Okay. I'd like to call Ann West.
I'm having no public input except lawyers. Is she admitted to the bar?
No, she's not, but...
Then she can talk to you. She can talk to you, and you can talk to us.
But I am a petitioner in this case.
She can talk to you.
Nope. I'm a petitioner. Why can't I talk to you?
I just think it's...
This is a legal argument case only. Mr. Berger, I gave you the last word. I'm now declaring the hearing to be closed.
All right, just let note my objection on the...
Are you representing someone, Mr. Kelly? No, I'm an attorney. I know who you are. The hearing is closed. The hearing is closed. We are done for the night.
Just note my objection on a violation of the open meetings law.
I took all the legal arguments that I'm going to take tonight. We have it.
Your Honor, this is a full-page advertisement in Newsday for the Indian Hills Country Club, which includes, contrary to the Judge Farnetti decision, has new construction on the bluff of Indian Hills. The continuing jurisdiction of the ZBA indicates that the ZBA can do something and can act on these matters.
Mr. Kelly, your comments are not on the record. Indian Hills is not in front of us. None of that stuff is in front of us. I've heard everything from Mr. Berger. I've heard everything from Mr. White. We as a board have heard everything. I've heard from Mr. McCarthy. The only thing in front of us was the application of Mr. Berger, and there's nothing else in front of us. Nothing else is in front of us. The hearing is closed. We are now adjourned.
You asked Mr. Berger what you could do. What you could do, Chair, is to enforce the code as Judge Farnetti indicated in Indian Hills.